Welcome to Ground Rules, Employment Law Over Your Coffee Break. My name's Pam Howland, and I'm here with Doug Plass and Jennifer Walrath. We are all attorneys with Idaho employment lawyers, and we spend our days trying to help our clients who are employers stay out of trouble. And that means we do counseling, litigation defense from claims and lawsuits, investigations, and training. And our goal is to give you enough information on the law so that you can stay in compliance and stay out of trouble. Today, we're going to be talking about what you can expect as far as changes go in 2025. And just a little background on that. Part of the reason that we decided to bring this episode to you was because 2024 was a crazy year. We had more changes in the law in 2024 than I have ever seen in any single year. For those of you who stayed on top of it, good job. Congratulations. It wasn't easy to do. We had new EEOC regulations interpreting the Pregnant Workers Fairness Act, for example. That happened in June. And if you looked at those regulations, then you would know that they were broad and that act has been interpreted to provide protections for many, many employers in the workplace. Hopefully you're staying on top of that one. Undoubtedly, you'll hear more from us about that in the upcoming year. Let's see, we also had what we call around here DOL whiplash. So we know that DOL regulations related to the salary basis threshold for the white-collar exemptions, we know that that salary basis test increased and that those regulations went into effect in early July. So I know that's a lot of legal jargon talking about what that regulation is. Hopefully, you knew that if you have exempt employees who meet one of the white-collar exemptions, that the salary basis test, which is the minimum amount you can pay them in order for them to keep their exemption, went up in July. It was supposed to go up again in January, but then all of a sudden there was a ruling from a court in Texas where that ruling recently got put on hold, and the DOL was found to have gone beyond its authority. So where we're at right now is that those July regs are no longer in effect, and the law went back to where it was as far as the salary basis threshold before July 1st. So we call that one DOL whiplash because for employers who worked hard to comply with the law, to a certain extent, they got punished by doing that because then this case found the DOL to be beyond its authority and that salary ended up not being necessary. So some employers raised the salary, and then as it turns out, they didn't really need to. So that's another thing that happened in 2024. Let's see what else. We had EEOC new guidance on harassment and discrimination, the first guidance we've seen in 20 years. And we had the FTC non-compete ban proposal, which was supposed to go into effect in September 2024. But a few weeks before then, it was invalidated. It did not go into effect, which, again, left the law on non-competes somewhat in question around the U.S. So in Idaho, for example, we still have our non-compete statute. It's still enforceable, but we're trying to predict what might happen in 2025. So I'm going to get Doug and Jen looped in here, and we're going to talk a little bit about what some of the predictions are as far as what we might expect to see in 2025. Of course, we don't really have any way to know. We're just watching the media, kind of watching authorities, seeing if we're seeing any indicators that we want to flag for you to follow. So What do we think?
I was
What's on
just,
your mind?
well, I was just going to throw in just to kind of follow up on the FTC non-compete rule that Pam mentioned and the overturning of the salary basis increase for the exemptions. Just to put out there that the Department of Labor and the Federal Trade Commission have each appealed those decisions. Unclear, though, when the administration changes, whether or not the new incoming administration and leaders of those agencies will keep pursuing the appeals. So even though there's currently an appeal on the books, which would suggest that, the decision could get reversed, chances are probably better that the appeals will get pulled and not pursued. And so we'll end up with not having any federal non-compete ban, at least for now, and not having any increase in the salary basis, again, for now. So,
because that's the other weird thing, right, is we had the administration change, and we have these agencies that are somewhat driven by priorities outlined by the administration. So when the election happened, change in administration, will the Trump administration have the same objectives for the DOL and for the FTC? Probably not, but we don't know for sure. So we can definitely expect that there might be some agency goals and expectations that change in 2025 when the new administration starts.
yeah, and I think one of the ones we've talked a lot about in our office, which is, I think, also a topic on a lot of people's minds, is what will happen with the EEOC harassment guidance. Because one of the really big issues that was updated and given, a lot of treatment in the guidance is protections against discrimination and harassment of employees who are within the LGBTQ plus community, and particularly issues of gender identity. So, the EEOC, very, very clear that those employees are protected. An employee who was, say, constantly misgendered by coworkers would have a claim for a hostile work environment and harassment under Title VII, which is the federal law that provides those protections against harassment and discrimination on the basis of sex.
And maybe everybody knows what misgendered means, but so an example of misgendering would be an employee who says they go by he, his pronouns, and then a coworker insists on calling them she, her pronouns, right? So that's when we say misgendering, it's those LGBTQ plus issues that are, in the big scheme of things, relatively new to our workplace, that employers are trying to maneuver through and get their brain around what the law requires in terms of compliance.
Yeah, and we'll just kind of see where sort of social norms have, for the last few years, been evolving. And kind of where this comes from, too, for those who may or may not know, there was 3 lawsuits they ended up at the Supreme Court in 2020 that were raising this question of, does the definition of sex in Title VII protect sexual orientation and gender identity? And the Supreme Court said that it did. So very clearly said you can't fire someone because of their sexual orientation or their gender identity. It's hard to say. So, but kind of left open other issues like bathroom usage and the gendering issue. Or, for example, if someone has transitioned from being a male to a female, not using their prior male name and using the female name that has been chosen by that individual. So those are the kinds of questions that sort of still remain to be sorted out. Again, the EEOC right now says all of those things are protected and employers should be doing what they can to prevent hostile work environments and harassment on that basis. But we have seen a lot of movement, including here in Idaho, from state legislatures and more local lawmakers pushing back against those kinds of protections. And, here in Idaho, for example, a law got passed last year that says a public employer, right? So when we say that, we mean like a state government, county government, city. What else am I thinking of?
School district, sort of thing.
Libraries. I mean, basically employers who have some kind of connection with the government that if you have a worker who is refusing to use someone's preferred pronoun, or is insisting on using their old dead name, that you aren't supposed to take any adverse action against that person. So it really raises this tension of what do you do, right? If you have a trans individual in the workplace who has transitioned and you have someone in the workplace who does not agree with that and refuses to acknowledge that person's preferred pronoun and preferred name, it's a tough situation.
Yeah, and I think that really sets up kind of one of the trends that we've been talking about a lot, which is this conflict between federal law and state law, in particular, when you have these state-specific statutes about transgender individuals, about bathroom uses, pronouns, that sorts of things, but also potentially First Amendment protections for religious expression. We see the conflict starting to bubble up in conflicts between Title VII and free speech. And what are employers to do when they have one employee who says, part of my religious expression is that I will not use anything other than the gender that someone was assigned at birth, and someone else who says, that you are discriminating against me by misgendering me and using my dead name or something like that. So no easy answers to those. And I think we're going to continue to see more and more of that sort of thing.
Yeah. So that puts employers in a bad spot, right? Not knowing, which part of the law they need to comply with. So here in Idaho, anyway, we haven't seen any actual lawsuits or action under that law that was passed in July, but we might this year, right? I mean, undoubtedly at some point, something's going to have to happen with that law. Either it gets walked back or it gets enforced, or some type of reconciliation is made between Title VII, which says one thing, and our state law, which says something else. But it does put a number of employers in a position of risk of liability, risk of running afoul of laws that are difficult to understand and apply if you're an employer. So stay tuned. We don't have all the answers on that, but you never know. This could be the year where we get some guidance on it one way or another.
Yeah, and I also was going to add too, we've heard rumblings from some of our clients of just increased political differences of opinion in the workplace, and that can, come out in the way that your different employees work together, how they communicate, and I think sometimes it's easy to dismiss those as just being differences of opinion and politics, but sometimes those differences might actually be things that need to be addressed under the laws that we're talking about. So just to kind of be aware that these issues are out there. And, you might well end up in a situation where someone's religious beliefs or their freedom of expression is in tension, with someone else's right to not be discriminated against under the current law. So
yeah,
not to dismiss everything as politics, although certainly that is there too. But
yeah, and that whole concept of civility, disrespect, I feel like over the past several years, we've seen an uptick in claims that come in the door. When we go to investigate them or resolve them, it appears that the claim is really rooted more in conflict in the workplace. So we get a lot of bullying claims, for example, and where we're at, bullying is not necessarily illegal. There is no law that makes it illegal. But when you have people in the workplace who are misbehaving, for a better word, who are treating people in a demeaning, degrading, excluding some, making people feel terrible, for lack of another word, it creates risk for the workplace, for sure. And if that type of behavior goes unchecked, Jennifer loves this phrase, but as the EEOC would say, disrespect is the gateway drug for claims of discrimination and harassment. So I would say now, as much as, if not more than any time in the past, very important for employers not to let bad behavior go unchecked. Do what you need to do to get it under control. Hopefully you've got policies that prohibit disrespect, lack of civility, bullying behavior. But if you're seeing employees at any level that are treating others that way. It's not always easy, but you've got to get that under control if you want to avoid claims and lawsuits. Otherwise, it's just a matter of time before that type of conduct spins into something bigger, like a discrimination or a harassment claim. So, I mean, other stuff like along the same lines here is we have a situation over the last year where federal agencies and their authority has somewhat been called into question. It's a little deep in the weeds, I think, as far as explaining, how that law plays into the employment law landscape. But I'll give it a shot anyway. These guys can correct me because they're a little more academic maybe than I am, but
A little nerdier.
okay, they're nerdier. I like that. But we had a Supreme Court case this last year that found agencies who, under prior law, courts had been required to give deference to agency interpretations of federal statutes. So to bring that back into the employment law arena, think about the Equal Employment Opportunity Commission, who interprets some of these big federal statutes, like Title VII, Americans with Disabilities Act, in the past year, Pregnant Workers Fairness Act. So we have some agencies interpreting federal statutes like the EEOC. And before, courts were required to give deference to how agencies interpreted statutes. But there was a recent United States Supreme Court case last year that walked that back and said that agencies are not entitled to the level of deference that they had been afforded before. So from my perspective, when you're looking at how the EEOC has interpreted some of these LGBTQ plus issues, and even looking at the EEOC guidance that came out last summer, which gave a lot of guidance on how employers should interpret LGBTQ issues in the workplace, the question becomes, will that somehow be called into question over the next year?
Yeah, and just to add in there, like for perspective, the prior law was in the place since like the 70s. So it's been like 50 years that, of law that has changed. So it's hard to say what's going to happen, but I think everyone is in general agreement that what it means is that whatever agencies say and do is going to be more susceptible to challenge in court.
Yeah, increased scrutiny, I think is the right way to think about it, yeah.
And it's going to run both ways. I mean, it's something where the first time we're going to start really seeing this is probably going to be challenges to administrative work, during, the Biden administration. But it's also the law that, unless it changes, will be in place after this next Trump administration's in place. And even the work those agencies do is only going to get so much deference. So at the end of the day, what I think where we're sitting in terms of what it means for employers is that it is going to make it a lot more difficult to comply.
Yeah.
To know what's expected of you at any given moment for purposes of compliance, and just going to make any of these issues worth a little more time and attention to understand where the law sits at any given point, and just keep on top of things, because really one court case could be more likely to change the landscape now than it maybe used to be in the past.
And one other thing about that I was just thinking about this afternoon is there's more, since there's more scrutiny on agency actions in terms of enforcing penalties on, on wrongdoers, we might actually end up seeing more litigation than in the past, right? So we have agencies aren't necessarily able to enforce kind of administrative penalties. They have to just file lawsuits. So there could be possibly an uptick in lawsuits filed by federal agencies like the Department of Labor, for instance. That's one that definitely relies on its own penalties in order to get stuff done.
Enforce penalties.
Yeah. So that
makes sense.
That's another thought as well.
So, I mean, I guess that leaves you a little bit in limbo. What should you do? Should you look at EEOC guidance? Can you rely on that when you're trying to understand the ADA or Title VII? I still think it's one of the best tools that employers have, because there's a lot of great guidance out there on the website that's free. that's available, where the EEOC has actually taken examples from the workplace and applied it to some of these somewhat confusing statutes. So, for example, you can, grapple with the Americans with Disabilities Act and think about, how about like mental health? How's that treated? And you can actually find some guidance on the website where the EEOC takes examples of real life scenarios and applies the law as the EEOC believes is the accurate way to apply the law. Really, I think it's the best stuff out there. So I wouldn't give up on it altogether. That's certainly not what we're saying. I think the big takeaway here is just that employers need to be on the lookout for changes. That's one of the things we talk about here a lot, is it's not enough just to have training every couple of years or to maybe, do some kind of like ADA training, every 5 years and think that you're good, because the law is constantly changing and in flux on these issues. And now, probably more important than ever with the new administration and some of this new United States Supreme Court law, employers really need to be paying attention to that. And so we're going to do everything on our end through this podcast, through our book, through LinkedIn, through our email blogs, everything we can to give you the tools you need to stay updated. So stay tuned. So we'll see you next time. Thanks for joining us with Ground Rules, Employment Law over your coffee break. Thanks.